My name's David Allen. I'm an occupational environmental physician. I've been in private practice in Western Sydney for a very long time. And we're lucky to have Michael Tooma. His profile is in the chat. Michael is probably the most prominent occupational health and safety lawyer in Australia and has written countless books on occupational health law. We're very privileged to have him today to talk about the legal implications of COVID for employers and people undertaking work. There is a link to an article from the Sydney Morning Herald, which was timely. It was in today. I'd strongly suggest you have a look at that because it's quite a bit of useful information about workers' comp and liability for employers. So, Michael, it's interesting in the context of the so-called opening up next week, what's actually going to happen. And a lot of employers, and I've had a lot of queries from employers about the implications for them in terms of their duty of care and obligations. And particularly from a health perspective, we're very interested in what the numbers do. And given the sort of the promotion of opening up by the government, what the implications are for employers. And I was wondering if you might comment on that.
Yeah, thanks, David. Great to have grateful for the invitation and good to speak to you about this. It's interesting. We've been conditioned to really think about the controls that we put in place in workplaces as being dependent on public health orders, and it's as if that the only reason why we have controls in workplaces is because of the public health orders. But nothing could be further from the truth. I mean, the reality is, if not a single public health order was propagated in relation to COVID, and we had the same outbreaks that we've had, every business would be duty bound by their duty of care to do a lot of the things that the public health orders have required. And this is crucial in terms of understanding what your obligations will be in states when they open up at 70% or 80%. Whatever the case may be. And I'm thinking particularly in New South Wales, come Monday, we open up partially for vaccinated persons. Come 1 December, we supposedly open up for everyone vaccinated or unvaccinated. And people are actually, kind of almost being told by commentators, politicians, media, or through their own belief that come 1 December, no rules apply. Well, you still got a duty of care. You still got to look after your workers. You still got to look after members of the public. And so you've got to do something about controlling the risk of COVID in the workplace.
So do you want to just give people who may not understand the employer's duty of care just a brief rundown of what that requires?
So in all states and territories, for a long time, there's been a duty of care that applies depending on the jurisdiction to either a person conducting business or undertaking. That's the case in all jurisdictions other than Victoria and Western Australia, or in Victoria to employers. And the duty of care requires persons conducting business or undertaking to ensure, so far as reasonably practicable, the health and safety of three categories of workers: workers directly engaged by you, workers caused to be engaged by you, and workers whose activities you can influence or direct. And then in addition to that, there's a duty of care to any other person at your workplace. And that duty of care requires you to ensure that they're not exposed, they're not put at a risk, so far as reasonably practicable, from the conduct of your business or undertaking. So if you step back and try and explain that, you've got a duty of care to your workers, and that's employees, contractors, subcontractors, employees of contractors, subcontractors. You've got a duty of care to others, members of the public, customers, and visitors, and the like. And that duty of care requires you to address all sorts of risks, not just physical harm, but obviously psychological harm. But importantly, we've forgotten the word health in work health and safety, or occupational health and safety. And COVID is an example of a health risk at workplaces, and so that's a risk that needs to be managed. And you've got to manage it by doing a risk assessment and working your way through the hierarchy of controls, introducing the appropriate controls, best controls available, exhaust those, deal with the residual risk by the best controls now available, etc. Use those controls in combination to make sure that the risk is reduced so far as reasonably practicable. Now, public health orders work in a different way. They are more in the category of prescriptive laws. Right? They tell you what to do and how to do it. and you've got to comply with public health orders because it's a legal requirement under the relevant Health Act in each of the jurisdictions. So if you're thinking about New South Wales, the Health Act. Public health orders are made by the Health Minister, and once they are gazetted, they have the same force of law. And if you breach public health order, you breach the Health Act. That's fine. But even if you remove the health orders, you still got your duty of care. Now, the duty of care is a duty that is a statutory duty. Breaches of duty of care are enforced by regulators, Safe Work in New South Wales and New South Wales, WorkSafe Victoria and Victoria, and so on, as Safe Work or WorkSafe in various jurisdictions. It operates at a state level. It is enforced by way of inspectors coming in and enforcing compliance with your duty of care. It can result in prosecution, but that's not the end of the story. Of course, under the general law, the law of negligence, you have a duty of care. It's a civil duty of care. It's at a different standards, not so far as reasonably practicable. You have a duty to take reasonable care with respect to obviously your workers, but also members of the public that use your premises and facilities. And if you fail in that duty of care, you can be sued for negligence if someone has suffered a loss or damage. For example, they got COVID, or they die from COVID, and their family member sues on their behalf, or in relation to compensation in relation to their injury. And those claims then are made against the various businesses. Now, the civil exposure is typically insured. It's insured for workers compensation, or employees anyway, workers compensation. For members of the public, claims made by members of the public, that's generally covered by general liability insurance. So you can take out insurance, and most people have what they call public liability insurance for their premises. The difficulty is, if you don't manage the risk associated with all of those risks, then you have a spike in claims, and the spike in claims will then affect your premiums because it's your claims history that determines your premiums going forward. So the idea that businesses could just from 1 December in New South Wales, or whenever the equivalent date is in other states, when you hit 80% in those states, could simply turn back the clock to the pre-COVID days is, in my view, irresponsible and naive. Now, that doesn't necessarily mean that in every setting a mandatory vaccination requirement will be appropriate. And vaccination is not the only control that you can deploy, but it's an important control. And the higher the risk profile of the business, the more you have to think about vaccination as part of the mix of controls that you need to put in place. For some businesses, vaccination may not be a reasonably practical control, but ventilation needs to be considered. Proper cleaning protocols, social distancing. You need to think about the mix of controls, PPE, mask wearing, even though that is the least effective of controls, needs to be considered in the mix of controls, depending on what your situation is as a business. The point here is that if you don't do a risk assessment and look at the entire gamut of controls, then you're not discharging your duty of care. And importantly, you can't just take off one control off the table, particularly an effective one like vaccination, because you don't like it. I mean, if it's not reasonably practical, that's one thing. If the risk profile doesn't warrant it, that's one thing. But if you just don't like it, that's not a defensible position. And that's the challenge.
Mandatory vaccinations is a very hot topic, obviously. I mean, if different places of work obviously have different risk profiles, but we're talking about, as we know, a potentially deadly infection. And if a workplace was to have transmission and someone got very sick or died, and they didn't have mandatory vaccination, how would they, and other employers have done it, so there's sort of an understanding that it's an effective measure, how would they defend that?
So let's step back, David, and ask the question about whether mandatory vaccination is a reasonably practicable control. And I appreciate this is a controversial topic. I know that there is guidance out there that purports to say that vaccination may not be a reasonably practicable control. With the greatest respect, I disagree with that guidance. Let me explain to you what I'm basing my analysis on, because it's something quite peculiar. It's called the law. It's a novel concept. You kind of base your legal view on the legal obligations and the sections of the Act. So, in order to determine what is reasonably practicable, you are required to follow the process prescribed in the Act itself. Now, that what I'm about to tell you is the case in all model law jurisdictions, so every jurisdiction other than Victoria and Western Australia, but Western Australia from 1 January will have from January onwards will have the same provision. But there's an equivalent definition in the Occupational Health and Safety Act in Victoria. So this applies wall to wall across Australia. What you're required to do in order to determine what is reasonably practicable is to follow a 5-step process. You look at the risk in terms of likelihood and consequences. So what do we know about COVID? We know that at the moment where there is high community transmission, the likelihood of getting COVID is pretty likely, right? We can grade it based on the state, but it's highly likely. And when states open up, will be even likely in those states where they have zero community transmission, right? Like Western Australia, for example. Then what do we know about consequences? Well, in order to determine the consequences, is it potentially deadly? It is potentially deadly. So you then have to say it's catastrophic consequences. So that's the first 2 steps of the process. Then you ask yourself, what do we know about the risk? Then you ask yourself, what are the available controls? And then you ask yourself whether costs, the costs associated with those controls, including whether those costs are grossly disproportionate to the risk. Now, the control itself is available because now, unlike 6 months ago, there is capacity in terms of vaccination. So you can go and get a vaccine in most states reasonably quickly. And we know that the science is that the vaccines work, and they work both on the individual level in terms of reducing the likelihood of actually getting COVID, and they work on the transmission level in terms of reducing the likelihood of you giving COVID to someone else. So it's an available control. If you follow that 5-step process, it's a reasonably practicable control. It's a control you can deploy. It's an effective control that even the worst critics of vaccination within reason would say is a control that reduces the likelihood of getting COVID or the severity of COVID or giving COVID to someone else. I don't think that position is deniable. And it's a control that at the moment is free. You go up to the federal government has provided for free. So the cost can't be grossly disproportionate. So which part of that 5-step process leads you to a conclusion that is not a reasonably practicable step? Now, let me step back then 1 step and say, is mandatory vaccination required or appropriate in every context? Well, the answer is no. Mandatory vaccination is not required or necessary in every context. Why? If you are performing work right now that can be done from home, so if you're working from home right now, right? If you're working from home, the risk of transmission of COVID, the risk of you getting COVID in the workplace from work has been eliminated because you're at home, right? You're working from home. You're not getting COVID from work. That still remains the safest place for you to be. Vaccinated, unvaccinated, it's a matter for you. But from a work perspective, very hard to compel someone on a safety ground, on a proper risk assessment ground, to be vaccinated if they're working from home. But if they are currently working, as in it's not reasonably practicable for them to be at home, right? That option is not, that top of the hierarchy elimination is not available. You're then in the substitution, well, you can't substitute, there's no substitute. Then you're in the isolation. In isolation, vaccination is an isolation control. It's a barrier between you and getting COVID. It's a barrier between you and transmitting COVID. And so therefore, it is the next available step in the hierarchy of controls. And if you're in that position, as in you're a business that has to continue to operate, you have to think about it as a control. Now, the other way to look at what is reasonably practicable is to look at it this way. The greater the risk, the more you're expected to do about it, right? It's almost that seesaw balancing act. I mentioned a 5-step process. 3 are on one side, 2 are on the other, right? The greater the risk, then the more that we have to do about that risk, which means that any business trying to grapple with this vaccination question has to look at their workforce, what the workers are doing and how they're performing their work, and then to ask the question, are they in a greater risk or a higher risk category such that I have to deploy vaccination as a control? What are the examples of that? Well, I have a high degree of interaction with a vulnerable community, healthcare, aged care, Indigenous communities, very young persons, so early childhood, or even young unvaccinated persons under 12s, so education, for example. Then you say, okay, the other possibility is that I'm in a dense workplace where there's a lot of people indoors, low ventilation. Well, that's going to be a situation where I'm in a high risk category. What about situations where I have a high degree of mobility, movement? I can be a super spreader person because I can go 5 or 6 workplaces before I can work out that I've got COVID. And if you work through that list, you'll find, if you are in transport of one description or another, if you are in healthcare, if you're in education, if you are in aged care, if you are working in those situations that I've described, such as door-to-door sales or doing audits and site inspections and moving around, all of those roles will end up being in a higher risk category roles. Now, I'm talking about roles, not industries, and I think this is an important point. A point of difference in my view is that you need to do this role by role in the traditional risk assessment profile. And you need to do it based on the work being done, not about some view of an industry, because there may be persons within an industry or even within a company that, even though they fall within an umbrella of an industry that is in a higher risk category, their work does not involve anything that is high risk from a COVID transmission perspective. And so therefore, in relation to those individuals, it's hard to justify why a risk-based approach would determine that vaccination is an appropriate control. Now, I wanted to just finish off on the vaccination point because I think it's an important one. Once you determine that vaccination is an appropriate control to deploy, people say, oh, well, we should just encourage people. We should just talk to them. I haven't heard a single person say, if you determine that a harness is a required and appropriate control to wear for managing working aloft, working at a height, that they should just encourage people to wear harnesses. Absolutely encourage people to wear harnesses, but it's a mandatory control. Not a single control that we have in place from a safety perspective is voluntary. Why is this different? Now, people say it's different because of bodily integrity and what they miss is that we have been requiring vaccination as a control in various settings for the longest time, and no one has even raised an eyebrow in relation to that.
No one, when complaining. I remember as a medical student back in the early 80s, we had to have our tuberculosis vaccination, and no one questioned it. It doesn't do much anyway. It has very little effect, but no one would ever query it. You just go ahead with it, and that's a duty to yourself, but duty to other people, I guess, and that's a really important point. I mean, the one of the things is being considered is workers' compensation for infectious diseases, and in my sort of 30 plus years in occupational medicine, very rare. It was very rare that people would claim workers' compensation for infections. They're perfectly entitled to do it, but demonstrating that it occurred at work, and also, that there was significant harm or damage done to them was a challenge. But obviously, the landscape of workers' compensation and infectious diseases has changed dramatically, I think, given, these life-threatening condition is so pervasive. And I also, the issue, and maybe if you could comment on that, but also on permanent impairment and death and common law negligence claim for people who are infected at work.
Yeah, so, in many respects, the workers' compensation position, or the position of workers to get compensation in relation to a COVID illness or God forbid a death, is pretty straightforward. If COVID was contracted at work, or work was a substantial contributing factor, then workers' compensation legislation, the definition varies between jurisdiction, but it's more or less the same as what I've just described. You are entitled to compensation. It's designed to be a no-fault system, right? It's not about what you've done or failed to do. It's, if you contract an illness, disease, or injury, suffer an injury at work, then you're entitled to compensation. So that's the starting point. That's not the end of the story, as you know, because if the injury or illness is severe enough, then you might make a common law claim. What's called a common law claim, which goes beyond workers' compensation, which is a claim that now alleges negligence on the part of the employer or the occupier of the premises, as the case may be. And that part is important in terms of what steps you've taken, because the liability is dependent on whether you've taken reasonable steps to discharge your reasonable duty of care. And so what you've done or failed to do becomes an important aspect to this. And contributing negligence comes into to those factors. Traditionally, as you say, infectious diseases have not been the poster child of compensation. In fact, we're almost obsessed with what we can see in terms of a physical injury, and we tend to lean into that. And more recently, we've seen psychological harm claims become more in vogue and prevalent. But for a long time, people would suffer psychosocial harm and would just take sick leave a couple of days, or retire from jobs and not make claims. The reality is that there are two dynamics at play here in relation to workers' compensation. One, this is a high profile pandemic. Everyone knows about it. They know about COVID. They know about the risk of COVID, and so visibly they know that they're exposed to risk, particularly if they're continuing to operate where others are not, particularly if they are facing public facing, etc. The second dynamic at play is that for good pandemic management reasons, we do a whole bunch of contact tracing and we do a whole bunch of genomic testing to work out who was patient zero, right? What was the source of the outbreak? So there's very good evidentiary basis from my perspective for working out where you got the COVID. Did you get it at work? Was work a substantial contributing factor, or did you get it somewhere else, at the gym or at home or somewhere else? And there's also good evidence as to who got it from you. So the liability doesn't stop with the person. It would stop with wherever else the liability leads if the outbreak has caused that. Obviously, that's not a workers' compensation claim. That's a different type of claim, but it's a claim nevertheless. So a prudent business would have to take steps to minimize that risk, in the same way you try to minimize all sorts of risks in your business, because one, you care about your people. Two, because you care about your legal obligations under work health and safety legislation and your duty of care and your personal liability and the penalties, and no doubt these are important factors. But also because you care about your premiums, because a run of claims will have a devastating impact on your premium profile, and you'll be paying for it for a very long time. So in a sense, this idea that we can just simply not worry about this when the public health orders are removed is, in my view, misguided and somewhat naive. And we've seen, you referenced the Sydney Morning Herald article. I mean, the expose there was just a number of claims that we've had during the outbreak. And one of the things that they talk about, of course, is the presumption in certain industries, essential services, essentially, that's the list of essential services, that if you got COVID during that period, you got it at work. And I suppose that what they're trying to avoid is people having to go through the evidentiary burden of having to prove something else in the process of proving that how they got COVID. Now, that's a rebuttable presumption. So the insurer on behalf of the employer could say, no, they didn't get it at work. You know, they got it for this reason, or they got it for that reason, or I can show that they got it, from a different source. So it's not the end of the conversation. It's just a presumption to allow people to claim, and also to get the benefit of the provisional acceptance of those claims.
That's a really good point, and the further to that is the issue of permanent impairment. So people, we know that COVID can cause heart problems, strokes, kidney damage, permanent lung damage, and the threshold for 15% for common law claims. I mean, that I suspect many organisations may not have considered what this could cost them in the long term, but it's a heart attack or a stroke or a cardiac arrhythmia or lung damage. It's not that difficult to get over the 15% whole person impairment threshold. Would you like to comment on that?
Yeah, I mean, I'm just noticing Anna's comment, and it's so true. It's long COVID. Long COVID is a big issue, and the reality is the things that you're talking about. I have no doubt that in relation to some of those claims that have been made and that were reported and exposed in today's Sydney Morning Herald article, won't stop at a workers' compensation claim. Because typically what you do, is wait until the full extent of the injury has crystallised before you work out whether you've met that threshold, a whole body impairment threshold, for common law claims, but also to work out the extent of the injury. Because if workers' compensation is sufficient to compensate you in relation to your loss and damage because of the injury, then that might be the whole of it. But if you've now suffered, in addition to the illness, you have suffered economic loss, you've suffered psychological harm, you've suffered long-term health impacts, such as the things that you've mentioned in terms of what's now colloquially being called long COVID, then you've got to be compensated for all of those aspects of your loss and damage, not just the initial period in which you were hospitalized or at home. So I think you'll find that the claims will increase, they won't decrease. But I'm less concerned about the immediate period. I'm very concerned about the world if people continue to have the mindset that come 1 December in New South Wales or come 80% in other states, and we're back to normal, everything is fine, don't worry about it. Again, I'm not saying that necessarily means restricting premises to vaccinated and unvaccinated. You just need to look at the control, the mix of controls, and make sure you're minimizing the risk of COVID transmission in your business. And don't be tempted to do what the UK is doing at the moment, which is, I think the technical term is let it rip. That seems to be the policy setting, and let's see what happens, because I can tell you it won't be a pretty picture for those who then will be at the tail end of the compensation conversation.
I mean,
even if the regulators don't enforce. Now, I just want to say something about the idea that regulators will enforce, and it's kind of the Prime Minister planted that seed somehow that no one's going to enforce vaccination on vaccination, and I wasn't sure the basis on which that statement was made. There was a lot of foreshadowing of some statements that were going to come from the regulators. Let me just say this: WorkSafe Victoria has prosecuted the Department of Health in relation to failings arising from the hotel quarantine outbreak. I think it's 58 charges were laid against the Department of Health. And recently, it was announced last week that an accommodation facility was prosecuted in relation to its duty as a control of premises. So, accommodation, hotels, that sort of not arising from the outbreak, but more recently in relation to COVID compliance. That's in Victoria. Safe Work New South Wales has prosecuted a number of construction companies for allowing unvaccinated people to enter their premises in breach of the LGAs of concern public health orders when those public health orders have applied. So our set prosecute, they fine them in relation to those matters. The idea that any single regulator would be so negligent that they would be asleep at the wheel in relation to mass outbreaks in the face of deficiencies in the duty of care, I mean, that would alarm me more than the outbreaks themselves. And regulators would lose all credibility if that was their view. I don't believe that is their view. I don't believe that is what they're going to do. And I'm not sure you find too many people who would take the view that is what they're going to do. So you've got the statutory liability and the risk of prosecution and enforcement, and rightly so. Anyone who thinks that regulators should not prosecute breaches of the law clearly have not worked overseas and haven't seen what that looks like if the regulator doesn't enforce the law, right? Because most jurisdictions around the world have relevant health and safety laws that look very similar to ours, but the extent of safety standards varies from jurisdiction to jurisdiction, based in part on the activism of the regulators and their desire to enforce any laws that are on the statute book. So just be careful what you wish for in terms of a world without regulations and enforced regulations. It'd be the equivalent of saying, hey, we know we have traffic lights, but we're not gonna, we've got a moratorium on any penalties in relation to traffic lights. Yeah, most people will adhere to the traffic lights because they can see the safety sense of them, but a whole bunch of people wouldn't. And that's the difficulty. You actually want laws to be enforced as a general proposition, fairly, but enforced appropriately. And so you still got that risk, and that risk continues. And even if it is not immediate, and even if regulators take a light touch approach right now, when there are mass outbreaks, I don't think they can afford to take a light touch. And so you're going to have the enforcement of these laws at some point as a breach of the duty of care. And so in many respects, we have to be taking this framework fairly seriously. Now, do I think there's going to be a whole bunch of industrial manslaughter charges in relation to? No, I don't. Is it possible? In extreme cases, yes. I mean, if someone just absolutely doesn't care, is indifferent to the outcome, they've got evidence of outbreaks, and they still pack people in workplaces and take a cavalier view, then I think it'll be unavoidable. But that would be a rarity, because it's a rarity right now. There are only one completed prosecution in Queensland, a second one on the way. It's not as if these laws are enforced every day. It should be the front of mind issue, but the duty of care, I think, needs to be.
I mean, the industrial manslaughter is a good point, and I wanted to ask you about that, because I'm not sure that everyone's aware of the industrial manslaughter legislation in Australia. Do you want to give us a brief overview of that?
So a number of jurisdictions have introduced additional penalties, if you like, for the most extreme conduct, right? So you've got the duty of care provisions operate. Then you've got categories within duty of care in relation to, severity of breach. And, when people talk about the maximum penalty in various jurisdictions, and a quote, $3 million or thereabouts, because it's been indexed in a number of jurisdictions, so slightly higher than that, and 5 years imprisonment. They're talking about category 1 offences. They're very rare as prosecutions. They require a degree of recklessness on the part of the duty holder. So you have a risk of death, or a risk of death or serious injury, and you've got the additional layer of requiring recklessness on the part of the individual for a category 1 offence. Now, on top of that, number of jurisdictions: Queensland, Victoria, and Western Australia, when the law commences in there, and Northern Territory, amongst the jurisdictions that introduced those provisions, have created basically a gross negligence offence, which is a separate offence that attracts the equivalent, if you like, of, and this is why the word manslaughter, of a manslaughter for an individual, right? So it's all about the imprisonment terms, and the imprisonment terms are significant for individuals, and the penalties are significant for individuals. So now you're talking about the kind of the 20-year type of territory for personal liability, and you're talking, and 10 years in some jurisdictions, and you're talking about the higher order kind of penalty figures. My view about industrial manslaughter is that it's a great headline grabber, but that conduct, I would expect, is so rare that you would expect a handful of prosecutions, in the course of a year across the country. It's not the sort of territory where people need to kind of be worrying about. But is it possible that someone could be so cavalier that they trip over that gross negligence threshold? Yeah, absolutely. It is possible. You could have a fatality arising from work, and that fatality, could have been caused by the gross negligence of a person that then can be linked back to the workplace. The sort of stuff that would trigger that breach, that type of breach, that sort of more extreme breach, would be knowing there's a problem, being indifferent to it, knowing there's an outbreak, doing nothing about it, or even worse, requiring people to be in exactly that position, and continuing to operate. That's where I think kind of more extreme views around that are more ideologically driven rather than risk-based or safety-driven, can be very dangerous, because if you're letting ideology dictate whether or not you let people into a workplace, or what conditions you require them to do, and we're seeing some of that extreme political discourse in the US, then this is when you get yourself in serious trouble in terms of the liability equation, because you're preventing yourself from being open to the possibility that certain controls can be deployed. And in the US, the debate is not just in relation to vaccination or not vaccination. It's about wearing masks, not wearing masks, and it's almost defiance of COVID and denial of COVID as a risk. That's the sort of extreme kind of discourse that I'm talking about. And if that ideology dictates you, then be very careful. And be very careful right now if you're making a stand, and you're making a point of making a stand. Because what sounds good as a news bite, on Facebook right now, and doesn't sound good anywhere else, by the way. What appeals to a small audience on Facebook will be great evidence against you down the track when those more serious charges are being deployed.
And I've had a lot of questions from people in schools, both parents of kids, staff in schools, about how to approach this. And obviously we've got private schools and public schools. People are concerned about their kids going back and perhaps bringing the infection home to them and to their more vulnerable family members. Have you got any suggestions as to how people in that situation might deal with the risk?
Well, in terms of the schools themselves, let's start with that. I mean, the schools have a duty of care. The duty of care extends obviously to the students, to parents, and then the liability could extend to foreseeable harm that could be caused through outbreaks and transmission. So long as that you can meet the threshold of causation, that the risk is not too remote, then you're within the scope of the liability. What should schools do? If that's your question, well, the starting point is the staff need to be vaccinated. The staff need to be vaccinated because that is a public health order and a legal requirement. So that's your starting point. The staff need to be vaccinated because that is a safety risk. And once the public health orders are removed, that will continue to be a safety risk and will continue to be an issue, and the staff need to be vaccinated on that basis. Then you've got to look at ventilation, right? And you've got to recognise that the trend in relation to ventilation has been going in a particular direction. It's about recycling air. It's about minimising the electricity use, the power use in relation to air conditioning systems, which again is all about minimising ventilation for good environmental reasons, absolutely. But the reality is we're in the kind of the more extreme end of ventilation. We're not designing premises to have a high degree of fresh airflow. We're designing premises, say, for actually high sustainability rating that actually deploy airflow through the premises as a way of minimising the air conditioning bills and the environmental footprint of ventilation. For the most part, we are trending towards less use of fresh air and less use of ventilation. Now, I'm not an expert on this issue, but I work closely with many people who are. And one person in particular has strong views about this, and that's Professor Mary Louise McLaws, and that's the use of HEPA filters and generally dehumidifiers and other kind of filtering arrangements. They've been deployed very effectively in a hotel setting, right, where the person is, particularly in hotel quarantine, where the person is in a room and what you're trying to do is minimise the risk of COVID in that context. So that makes sense. But it seems, and I'll defer to the expertise of others on this, but it seems that based on the advice that I'm led to believe, that they'll be less effective in an environment where you have multiple people in a room sharing the same air, and you're trying to use that as a way of purifying the air from COVID. So my only advice, because it's not my area of expertise, my only advice is get expert advice on these issues. Don't just kind of think something is a good idea and follow it. Go out and get some expert advice. Do a proper risk assessment. Improve ventilation, because in many ways it may well be that taking kids out of the classroom and doing more outdoor based setting for learning, or opening windows. Or introducing a mix of controls, and it may be that may be the based on advice, the preferable way to go. And my point is here that you need to go through that risk assessment and get access to advice. Don't just
wing it. Yeah, I mean, I think, and any employer of a substantial size or with significant risk, should be engaging engineers and occupational hygienists to look at it. I guess, that to me is a no-brainer, and looking at how to, increase your air changes as much as you reasonably can. I mean, given that there's a ventilation audit going on, for instance, in New South Wales through schools, what's the best way for parents and concerned staff getting information on what's been done, what the air changes are like? They should approach their institution or their safety committees or the government. I'm not sure where to get that information.
And David, the first thing is being alarmed is not what we're calling for here. Being informed is what's appropriate, and having a proper, constructive, expert led conversation is what I'm really advocating here. So absolutely have a conversation with, if you're a concerned parent, have a conversation with the principal, with the safety committee of the principal of the school. Have a conversation with through the parent and teacher forums. The conversation should happen at a school level. I think my strong view is that too many of these conversations are being deferred to the government level, where the solution can't be the same across all premises, all institutions, all workplaces. And part of the reason that I think we've missed a step here is that we seem to just want someone to tell us what to do. And we're not just doing the thinking, because sometimes in a particular setting, ventilation can be maximized by some of the things that we're talking about, opening windows and reducing the number of people in classrooms and going outside and doing those type of things, rather than thinking about every school as being the same. Every setting is the same, that every cafe is the same, every restaurant is the same, right? And again, we keep on wanting solutions. We keep on saying, part of the debate, we go back to vaccination. I find this staggering that people are saying, look, this is very hard. How are we going to exclude unvaccinated people from premises? And I think, okay, if you're underage and you want to buy grog, people ask you for ID. And if you can't show ID, you can't buy alcohol. You can't go into a bar, a nightclub. If you are intoxicated in premises, be that a place where you can be intoxicated, or as in a bar for responsible service of alcohol reasons, you can be asked to leave. But if you're disruptive and behaving badly in a retail shop, you can be asked to leave. The idea that we don't know how to enforce laws based on the fact that that property is private property, and that you are essentially there on the terms and conditions of the occupier of that property. You don't have a right to be on private property. I just don't understand that narrative, that discourse. It really kind of, we could make an argument that everything is hard. Every regulation is hard. Every law is hard. Every restriction, every rule is hard. Absolutely. The problem is that with a bit of thought and a bit of positive approach, you can find a solution for almost anything. And so, the reality is that I don't think any of those restrictions are particularly onerous or particularly difficult for people to comply with. I think the difficulty is that we keep on just wanting the government to tell us what to do and to make it as simple as possible for us to do it. And then we complain when they prescribe all sorts of rules that don't have an impost and a cost on us. We should be saying to the government, we're perfectly capable, because we have done this for a very long time, to assess our own risks and to introduce controls. We need to stop pretending that we're incapable of doing that, and we are perfectly capable of bringing in expertise and working with the affected community and consulting and engaging and introducing fair and reasonable measures that are commensurate with risks. That's the key message for me. And I think the more we move away from that, the more it's about control and command and control and rules and more rules. We need more clarity. More clarity requires more rules, and then rules upon rules upon rules. And then we're surprised when those rules are inadequate. And let me give you an example. We had rules in relation to public health orders that apply to certain categories of workers in New South Wales in relation to their vaccination status. Those rules have been removed and new rules have been introduced requiring different categories of workers to be vaccinated and prove their status in relation to vaccination. In the changeover from one set of rules to the other, a bunch of workers who used to be required vaccination, presumably on public health grounds, require it today, right? From Monday won't require it. Then a bunch of workers who today don't require it will require it. And I mean, we know from history The more rules we create, unintentionally we will miss things. And then when we miss things, we're always very surprised that we've missed them. Well, yet safety practitioners have known for the longest time that you can't prescribe all the conditions of work. And so that's why you end up with a mismatch between work as imagined in rules and work as done in practice. And we just need to go back to the basics of engaging with people on the ground and working out what the needs are, and then creating the set of controls that are appropriate for protecting people. This is about protecting people. It's about protecting workers, it's about protecting members of the public. It's about feeling safe in accessing services. It's not about telling people what to do. It's not about status or exclusion. It's about how do we introduce safety controls that are commensurate with the risks.
Okay, so that's good. We've got a bunch of questions. I'm wondering if we want to work our way through those.
27, I can see. I clearly am controversial.
Where would you like to start? Can you?
You far away, and I'll answer.
Okay, I'm just scroll. So institutions such as university exempt from a public, if an institution such as uni is exempt from a public health order, are they still bound to a civil duty of care?
Well, again, this comes back to the point that I made at the outset. We've been conditioned to think that the public health orders are the be all and end all. I mean, if you want to think about it, the public health orders are the health authority's way of saying, listen, this risk is so bad that we feel compelled to introduce a prescription or regulation about it. How effectively they do that or not, we can debate. We can debate why an industry is bad in one state and not another. We can debate all that. But that's essentially, if you think about it, it's like, here is an analogy that I gave to a client the other day. When you're going out and assessing your risks, you're probably oblivious to the fact that there are 700 pages of regulations that prescribe controls in relation to various high-risk situations. Take confined space. That's a prescribed risk that has to be dealt with in a particular way. Working at height, a prescribed risk that has to be done in a particular way. The electrical safety is prescribed risk that has to be dealt with in a particular way. And in fact, I've written books on each of those, not confined space, but each of those topics, because there are rules that govern this. And the hierarchy of rules are, your duty of care, you've got the regulations and what they prescribe in relation to those high-risk situations. Then you've got the codes of practice that determine how you unpack all of those things. And in combination, that's the body of law that applies to working at heights or electrical safety, for example, to use those two examples. Does that mean that you are permitted not to control any other risk in the workplace? Because I mean, surely if that was a risk, then the government would have prescribed it. Well, the answer is no. I mean, I can point you to the thousands of cases that are brought against the other risks. And in fact, those risks, even when they're prosecuted, they're not prosecuted as breaches of the regulations, they're prosecuted as breaches of the duty of care. For working at heights is not prosecuted as a regulation breach, it's prosecuted as a breach of the duty of care. Electrical safety is not prosecuted as a typically a regulation breach, it's prosecuted as a breach of the duty of care. All it is just calling out certain things that are such high risk that we need to make sure that people know about them. That's the best way to think of the public health order. So absolutely not. No industry is exempt. No industry is outside the bound of the analysis that I have described. The conclusion that you might arrive to may be different depending on the industry. So after a risk assessment, you might come to the view, well, I don't need to introduce those controls because those controls are adequate. And that's fine. But what I'm asking people to do is to turn their minds to the risks and follow a proper risk-based framework and access expertise where appropriate, Because if you decide for whatever reason that certain controls that are higher order controls are not going to be deployed, for example, such as allowing people to come back to the office because they're no longer working from home, well, the onus is not going to be on you to make sure the controls that are in place in the workplace are adequate to cater for those changes circumstances. And so you've got to double down on other controls. And so in many respects, it's the mix of controls that is important. It's trying to move things up the hierarchy of controls as much as possible. And it's looking holistically at a risk management, risk-based approach, and that is required by the law.
Okay. So if a worker were to be concerned about returning to work from working from home, they say, well, we need you back in the office. That's a bit of an interesting topic, isn't it? And they duly go in and they take their little carbon dioxide meter to look at their office and see that and find that the ventilation's not up to scratch and they've got high CO2 levels. They could say, I feel unsafe, and effectively say, I don't want to be here, couldn't they?
Well, so your starting point is under the common law, under the Fair Work Act, and under the Work Health and Safety Act, a worker has a right to refuse unsafe work, right? The process under the Work Health and Safety Act that they have to adopt in order to do that is to tell their PCBU that they regard the work to be unsafe, and to engage in a consultation with the PCBU in relation to that, but they can refuse unsafe work. A health and safety rep could direct workers not to perform unsafe work, and there's a whole process that can be then adopted in order to determine what is safe and unsafe work. Now, the reality is that that then requires you, once a worker has made that determination, that then requires you to then engage in a dispute resolution process. And one of the amazing provisions of the Work Health and Safety Act that no one has paid enough attention to, or no one will not pay enough attention to, is the dispute resolution provisions in the Work Health and Safety Act. But if someone has a dispute, two duty holders have a dispute, or two people have a dispute in relation to work health and safety matter, they're going to try and resolve that dispute. If there's a policy in place on how to resolve that, you follow that policy. If there isn't, then you follow the rules that are provided in the Act and regulation, and then ultimately that leads to bringing in a safe work inspector to mediate between you in relation to that dispute. The thinking is that will allow you to resolve that dispute. So this is the most fascinating part of the debate that we're having. I find it mind-boggling that people are talking about this conversation around vaccination, unvaccination, and safety from a COVID perspective, without the context of the right of a person to refuse unsafe work. For this reason, we seem to be fixated with people's perceived rights that actually don't have any legal standing. I have a right to refuse. What about the unvaccinated and their rights? Well, it turns out you got to ask yourself, what about the vaccinated and their rights? Because the vaccinated are the vast majority of your workforce, and they have rights that are crystallized in the Work Health and Safety Act. They're there in black and white. And we're talking about the minority that actually may have a right to refuse to be vaccinated, right? But they don't have a right to work unvaccinated. And so we've become tangled up in a perception of the fact that a medical procedure requires consent. It absolutely does. There's no doubt about it. A medical procedure does require consent, and a person then needs that to give that consent freely in order to be vaccinated. That is absolutely a conversation that needs to be had between the patient and the medical practitioner, nurse, or whoever who is administering the vaccine. And if that nurse is not convinced that the person has given consent, then the act of giving that vaccine is assault and shouldn't be done, right? That's a very valid conversation to be had with those two individuals. But if If you turn up with a status of being unvaccinated where a public health order requires you to be vaccinated, or a workplace policy rightly, after a risk assessment and proper engagement, determines that it's unsafe for you not to be vaccinated, you don't meet the inherent requirements of the job, and therefore you can't perform that job, and therefore you're not available to work. It is your status and your fitness for work that is the conversation, and not whether you got vaccinated or not. And this is no different to any other type of fitness for work conversation. It's about whether you present a risk to health and safety to yourself and others by your fitness for work. If there's a proper risk assessment, and this is the requirement, then now, what does that mean? It means that there is actually if you don't do the risk assessment, you have no chance to actually have a conversation with workers who perceive the work to be unsafe, and therefore to resolve that in a proper manner. If you do the risk assessment and proper consideration, and you have come to the view properly with proper advice that the work does not require vaccination, then you will have a basis for having a conversation with the vaccinated person who perceives it to require vaccination and perceives the work to be unsafe, unless you provide a vaccination a policy as a control. It all marries up to what the law has always required, which is a risk assessment. And in many respects, the public health orders have become a distraction to the risk assessment process that is required by every business, and that is a necessity in order to navigate these issues as we go back, because that's going to be your best friend against a situation where people refuse to do work. That's going to be your best friend against claims for common law claims by workers in relation to for negligence. That's going to be your best friend against class actions by members of the public in relation to outbreaks. It's that risk assessment and robustness of that risk assessment. And if you find that if you do that risk assessment properly, get proper advice, vaccination will be an issue for some workplaces. It will not be an issue for other workplaces. It will be an issue for some work. It will not be an issue for other work. And that would be the right settling point in relation to this debate.
Great. Okay, thanks. We've got so many questions, and if there's any burning questions, if you can just perhaps repost it, because there are dozens and dozens of them, and we're not going to get to anywhere near all of them. So my apologies if you've got any. The last one here.
Feel free to reach out. I'm reasonably easy to find. Just hold off on your hate mail, because I'll just delete.
you might, but I've been inundated with messages from our last webinar, and it becomes very hard to respond to them all. So, I mean, the other possibility might be to revisit this at a later date if you've got time to answer all the questions. So, are you okay to answer a couple more, Michael? Or
let's do that.
Workers' duties. What are your thoughts on how they meet their duties if not vaccinated? I think you've covered that pretty closely now. The number of people wearing masks in room versus unmasked. That's another conversation. We will be running a webinar on masking. So if you stay tuned on that website link, that will be coming up very soon. How can DET have blanket advice on an open window is adequate? Look, I think, as Michael would said, you need to do a risk assessment on each situation. If you look at the previous webinar video, it does talk a lot about ventilation and assessing that. So I'd suggest you maybe have a look at that. That's a very long one. As a building scientist, it's very important to differentiate air leakage and ventilation. Air leakage and ventilation are very different things. I mean, that's a very long question, but I mean, I would add a comment that there are health benefits by improving ventilation beyond infectious diseases. If you look at Harvard Healthy Building, that's Harvard University Healthy Building talks a little bit about the benefits of fresh air. I also suspect, and Michael may have a comment on this, that codes of practice on ventilation for infectious diseases and in general are likely to come about fairly soon. So whatever changes you make are probably for the long haul, I would suspect. Michael?
Yeah, look, I mean, the point I will make in ventilation is act as expert advice and do a proper risk assessment, David. I mean, that's the point that I want people to do. It's not for me to tell them what to do, because actually, I strongly suspect that the answer for one building will be different from another, and one setting will be different from another. Opening a window may be an adequate control, someone said, in some settings, but it won't be adequate in a different setting. And the point is to access expertise. It's not I mean, the frustration here has been that there is a lack of desire to bring in the experts to help you through this process, and a desire for government to give you answers. And whatever answers governments have tried to do, by necessity, are generic. And if you analyse them closely, they're not much guidance on any given situation. But what do you expect? They're dealing with all businesses, all employers, all industries. And I don't think there are generic answers. So I think accessing expertise is the right answer.
Yeah, and I think, as you said, every workplace is different, and every ventilation system situation is going to be different, and the risk profile is going to be different inherently. I've just mentioned there in the chat the Australian Institute of Occupational Hygiene. I would strongly advise you to have a look at that, and also talk to your HVAC, heating, ventilation, air conditioning engineers. I mean, I think erring on the side of caution and to do your risk assessment properly. And unless you're really aware of what your air changes are like and your CO2 levels, which most employers wouldn't be, I suspect, you do need to seek expert advice. So getting an occupational hygienist, particularly who specialises in ventilation and in concert with your HVAC engineers.
We'll have to wrap it up here, David, I'm afraid.
Thanks very much.
Pleasure.
Feel free to contact us if you want any more information, and we'll do our best to let you know. Thanks very much. And look, if everyone can complete the survey afterwards, and we will be running more webinars in the future. Thanks, Michael.
Cheers. Bye-bye.
All the best. Take care. Stay safe, everyone.